Hi, I'm Rob Carolina. This is one part of a multi-part introduction to the Law and Regulation Knowledge Area of CyBOK. The Law and Regulation Knowledge Area is one of 19 knowledge areas in the entire project. The webinar that introduces this knowledge area is pretty long, and so I decided to break it up into 15 constituent parts. You are now about to listen to one of those parts. If you haven't already done so, I would recommend that you go back and listen to the introduction. It's also labeled Part 0. That'll help you understand what's about to happen. Alternatively, you can listen to the entire webinar as a single file. So without further ado, let's listen to this part. Okay, let's look briefly at the subject of computer crime. Computer crime really brings up three different possibilities. Either the internet is an instrumentality of some other crime, or we're talking about a crime based on message content, or we're talking about a crime against information systems themselves. I haven't written about the internet as instrumentality because otherwise we'd be writing about every possible crime on the face of the earth, and I think that just kind of rapidly spins out of control. I also haven't really written at all extensively about content of message crimes. And that's because it's extremely difficult. This is a very sensitive topic, and it's very difficult to abstract out international norms in this particular space because there's always a tension between a given society's desire to limit illicit message content and their desire to promote freedom of expression. About the only place where you find international agreement these days on message content has to do with content that is concerning abuse of children. And I have made a brief reference to that. But mostly what I've used this section for is to explain a bit more about crimes against information systems. And as you can see, they fall into 5 categories. Improper access to a system. Usually this is synonymous with the term hacking, the idea of trying to break into a computing system of some type without authorization. Improper interference with data, which is to say, rearranging, deleting, messing about with the contents of a computer. Improper interference with systems. Here we have anything that would decrease service viability, denial of service attacks. Improper interception of communication. Now, we've already talked about that. And producing hacking tools with improper intentions. There are a number of recurring challenges that come up with these types of crimes. First, lack of universality. Not every state in the world agrees that these things should be criminal. Secondly, extradition. It's very well known that there have been cases where it's difficult to gain extradition of somebody because they have committed a crime against an information system. The third point here is, how do you measure harm with respect to these types of crimes against information systems? In some systems, for example, the crime is conceptualized as an economic crime, and the punishment to be meted out and the severity of the crime is directly related to how much financial damage you can demonstrate was done by the criminal. Whereas others don't seem to operate that way. And since we have difficulty measuring harm, that leads on to problems of should we have de minimis exceptions, and should there be other types of exceptions to these laws. So on the right-hand side of this slide, for example, should we have exceptions built in for research and development activities? Other problems that come up on a recurring basis: warranted state interception. If you give a state agent a warrant to intercept communications, by extension, they're probably also breaking into a computer somewhere, or they might be breaking into a computer, or do you want them to be able to break into a computer in order to execute that interception warrant? This comes up again in public international law. Finally, a recurring issue in this area of law is so-called self-help, especially hackback. Generally speaking, we can say that the law doesn't like self-help. Self-help is just the process of, if you want to enforce your rights, do it yourself. Don't bother to call the police, don't bother to go to a law court, just take the law into your own hands and enforce the law yourself. That's usually, for a lot of very good policy reasons, not encouraged. And hackback is an example of self-help, where somebody says, well, I'm being attacked, so I want to turn that back around. So I've written a little bit about, and I've given citations to a number of really thought-provoking articles on this subject of hackback. Let's